that the initiative has been supported by at least 1 million registered voters. My Lord, a clear reading of Article 257(4) shows that what IEBC is supposed to verify is not signatures, we agree, but whether the initiative has been supported by 1 million registered voters. Now, the instructive words, Your Lordship, is to verify and supported, as opposed to merely ascertaining whether the list presented to them is those of registered voters. What Mr. Kipkogei told us is that in their understanding, they were only supposed to look at the list presented to them and ascertain that that list is a list of registered voters. Nothing can be further from the truth, Your Lordship. Verification, as a matter of necessity, Your Lordship, must connote and include an element of counter-checking, whether indeed the persons whose names appear in the list have actually endorsed the initiative. They must come up with a system that is foolproof to establish that indeed those signatures have been issued by the purported registered voters. Why do I say so, Your Lordship? Let's go to Article 88 of the Constitution, where IEBC has a duty to conduct referenda and elections. And Article 88A, they are supposed to conduct and ensure that an election or voting is done in a manner that is simple, accurate, verifiable, secure, accountable, and transparent. That is a duty that has been imposed upon IEBC under Article 86A. Now, I would imagine then, Your Lordship, that if that duty is there in matters election, a higher duty is meant to be employed under Article 257, where we are talking about amending a constitution. Because, of course, amending a constitution is a higher civic duty than even an election. So what we are saying, Your Lordship, is that verification under Article 257 cannot just be to look at the names and confirm that those names appear in the register of voters. In any case, it was admitted by my learned friend that they do not have an updated register of voters. That the last time that was done was when we had the Kibera by-election. Now, obviously, we have people who have left us by death, through death rather, whose names still appear in the register of voters. So if then what was required is to confirm that a particular name appears in the register of voters, it means that there is an opportunity or a room for malpractice. What it means in a nutshell then, Your Lordship, is that anyone seated in a room can come up with a list of 1 million names, put a semblance of a signature against the name, and if it happens that those names are names of people who are registered voters, they only need to present that to IEBC, and IEBC will be satisfied that indeed the initiative has been supported by 1 million registered voters. That is not the kind of duty that Article 257 intended to bestow upon IEBC. It must be a higher duty of ascertaining, taking measures. And to end on that point, Your Lordship, when you look at Article 86D, it says that IEBC is required to put into place appropriate structures and mechanisms to eliminate electoral malpractice. So even in the instances where they are verifying signatures, That duty under Article 86 exists. They must tell us what mechanism and structures they have put in place to avoid that kind of malpractice. On the submissions by my learned friend on behalf of Parliament, it was indeed admitted that we do not have a legal framework, that we do not have a referendum law. But they were quick to say that, to shift the blame to unknown persons who are supposed to petition Parliament to come up with the referendum law. That duty rests upon Parliament. It is not upon any other person. That admission in itself is enough for this court to confirm that indeed we do not have a legal framework, number one, for collection of signatures, for verification of those signatures, the manner, procedures, and the threshold of the debates at the County Assembly and Parliament, the uniformity of such debates and procedures. We do not have that law. The Elections Act has not addressed these issues. We were not given any provisions that purport to address those issues. So, Your Lordship, I would urge you to be guided by the judgment in the Nubian Rights Forum case, popularly known as the Mutuma case, where the court said that where there is lack or inadequate legal framework, the proper remedy is for the court to stay that action until we have a proper legal framework in place. I urge Your Lordships and my lady to proceed and make the same announcement. On the submissions by my learned friends, Mr. Paul Mwangi and my learned friend, Mr. Arnold Oginga, it has been argued that our petition is res judicata on two accounts. It has been brought to your attention a petition filed by my clients, 451 of 2018. I invite the court and the bench to read the decision of Justice Mativo. It will come to the conclusion that the issues therein were totally different from the issues that are before you today. Petition 451, Your Lordship, touched on issues surrounding the establishment of the defunct BBI Advisory Task Force. The court went ahead and stated that the president had the right to appoint a task force to advise him on any policy issue. It never went ahead to interpret Article 257. We are before you for interpretation of Article 257. We are not here for any other business, Your Lordship. That was not addressed by Justice Mativo. On JR 271 of 2019, the Kirinyaga County Assembly matter, again, Your Lordship, this was a judicial review matter seeking orders of mandamus, asking the court to compel the Speaker of the County Assembly of Kirinyaga to reintroduce the Punguza Mizigo Constitutional Amendment Bill of 2018. It had nothing to do with interpretation of Article 257. The Honorable Judge was not called upon to interpret that section. Though inevitably, Your Lordship, and we admit that the judge made certain judicial comments which came in form of a recommendation. Having established that indeed we have a lacuna in the law, she went ahead and recommended and said that a certificate should be forwarded to Parliament for enactment of a law that is to guide on debates, transmission, and the general procedure surrounding Article 257. She never at any point attempted to interpret Article 257 of the Constitution. Therefore, the argument that indeed our cases are res judicata are misplaced. Lastly, Your Lordship, you've been requested by my learned friend, Mr. Arnold Oginga, to declare the exhibits that we have annexed as inadmissible because they are newspaper cuttings. And in making that submission, my learned friend relied on the Agulaya case, which I participated in, presided over by Your Lordship, Justice Ngugi and Justice Odunga. I wish to distinguish that case, Your Lordship. the rationale in rejecting the evidence presented by way of newspaper cuttings in the Algurea case was because the court found out that the information sought to be relied upon under those cases was information that had emanated from the petitioners themselves and caused that particular information to be included in newspapers, then sought to use that same newspaper as evidence. What we have produced by way of newspaper cuttings, Your Lordship, are matters and facts that are within the public domain, undisputed facts. In fact, we need not even have attached those newspaper cuttings in the first place. We only needed to bring those facts by way of an affidavit to court. If there was any allegation, Your Lordship, in those in that affidavit that is not true, the Attorney General, who is the main respondent, ought to have filed a replying affidavit in response and in rebuttal to those allegations. Now, I note, Your Lordship, that to date, there is no replying affidavit sworn by any government official that has been brought to your attention in rebuttal of any of the facts that we have adduced by way of an affidavit. Those allegations have only been made from the bar and cannot stand a court of law. Lastly, Your Lordship, I would thank you, Your Lordship. Lastly, Your Lordship, I would ask the court to be guided by the definition of a popular initiative as captured in the 9th edition. Your Lordship, can you hear me now? I'm asking the court to be guided by the definition of an initiative that appears in the law, in Black's Law Dictionary, 9th edition, and it will find that a popular initiative must be a process from the people and by the people. On whether we have veered off our pleadings, I beg to differ, Your Lordship. We brought to the attention of the court by way of a further affidavit the happenings and developments at the county assemblies, and the court was well aware that this petition was challenging a process that is ongoing. In fact, in your ruling at paragraph 60, you warned the county assemblies that should they purport to conduct this exercise in a manner that it does not meet the legal threshold, that you would be watching and you would nullify the process. So if we brought any evidence, it is because we were well aware that it is a process that is ongoing. I rest my case, Your Lordship. Thank you.